Hello and welcome everyone. My name is Yasir and I'm your tutor for Law of Accounting, Part 2. Any questions, any concerns, or can you guys see my screen and can you hear me? Everyone, if quickly can say yes.
Yes.
Yes, yeah.
Okay. So if there is any issue, just please let me know, okay? So this is Part 2, and in previous session we discussed intellectual property law, then we discussed data protection, and then employment laws. Today we will start from equal opportunity legislation. Uh, Equal opportunity. Any comments? If anybody know about Hanesh or anyone else, if you ever heard about Equal Opportunity Act 2010.
Yes, it's legal rules regarding the employment of staff within any organization, and they have about 7 or 8 protected um, individual points against their employment, especially after 2 years of working within the same
Yeah,
organization.
yeah, that's correct. So basically, Opportunity Act 2010, when became effective August 2012, serves as important framework with the primary goal of promoting the recognition and elimination of discrimination, victimization, and sexual harassment. So the act aims to foster an environment where these issues are identified and addressed. Equality Act 2010, safeguards various characteristics, including, you can see here, age, disability, gender assignment, reassignment, marriage, civil partnership, pregnancy, or race, religion, or belief, and, sex. So here, if you want to read about, any of these legislations or, rediscovering process values in employment, grievance procedures, or employee potential legislation and SME performance, you can go these websites and, you can read about Data Protection Act, data, redundancy, and your rights towards employment laws. Then again, here some websites, for your reference. So backup slides. ACAS code of practice emphasizes several key principles to guide actions in the workplace. It underscores the importance of promptly raising and addressing issues, maintaining consistency in actions, conducting necessary investigations, providing individuals with the opportunity to present their case before decisions are reached, uh, allowing allowing formal meetings and ensuring the right to appeal. Uh, these principles contribute to a fair and transparent approach in handling workplace matters as outlined by the ACAS code for practice. Disciplinary established facts, investigatory meeting, investigate fully and collective evidence, no disciplinary action at the investigatory meeting, suspension must be paid short a time as possible. So disciplinary establish facts during the investigatory meeting. It is crucial to conduct, through investigation. Uh, Yeah, through investigation, collecting evidence to establish facts. If no disciplinary, action is deemed necessary during this meeting, any subsequent suspension must be uh, paid and kept as brief as possible. Okay. Disciplinary inform ideally 3 days written notice, give full details, including copies of evidence, say if dismissal is possible, right to be accompanied. So, right to accompany, the right to be accompanied extends to a fellow workers, a minute taker, or a union representative during disciplinary proceeding. Even you can, I think so, in some companies you can bring someone from outside as well, but not solicitor. Meeting a fellow worker, union rep, and minutes worker again, and the meeting review your evidence, prepare question in evidence in a confidential room, no no interpretation, remind of right to be accompanied, stay calm, adjourn before making a decision. So make the meeting in a confidential room, review the evidence, prepare question in advance, and ensure an uninterrupted environment, remind the individuals of the right to be accompanied, maintain a calm atmosphere, and adjourn the meeting before reaching any decision. So disciplinary decision making assess the need of for any disciplinary actions, considering the presence of secret recording, if warranted, determine a reasonable sanction, confirm it in writing, specifying the reason and expected improvement, carefully word the communication, and set a time for review if improvement is not observed. The decisions remains current, for a limited time, and the individual retains the right of appeal. Hmm. Sorry. So gross misconduct, immediate dismissal for first offense, follow a fair disciplinary process, no notice, notice pay will be due. So dealing with the instance of gross misconduct involves the immediate dismissal for a first offense, emphasizing the importance of following a fair disciplinary action. Process. In such cases, no notice or notice pay will be due to the individuals. Uh, Appeal process can appeal against any disciplinary action. Insist appeals are made in writing by a set time, mirrors disciplinary process. Manager not previously been involved inform of the outcome as soon as possible, no further right of appeal. So regarding the appeal process, individuals have the right to appeal against any disciplinary action. The appeal should be submitted in writing within a specific time frame, and follows a structure similar to the disciplinary process. It is very crucial that the managers handling the appeal has not been previously involved. The outcomes of the appeal should be communicated promptly, and there is no further right of appeal beyond this stage or final stage, after outcomes or appeal, last appeal. Then grievances, establish the fact notice of formal hearing, right to accompany decision after the meeting, information they accordingly right to appeal. Basically, when addressing grievances, the initial step is establish the facts surrounding the issue. After this, a formal hearing scheduled, and individual has right to accompany during the process. Decisions are made after the meeting, and individuals are informed accordingly. So, if satisfied with the outcomes, there is a right to appeal the decisions. This ensures a comprehensive and fair approach to resolving workplace grievances. Recommended actions follow the ACAS COP for all disciplinary and grievances. Suspend with pay while investigating a gross misconduct. If you are unhappy with performance, act early. So basically, recommended actions adhere to ACAS code of practice for both disciplinary and grievances procedures. When investigating gross misconduct, consider suspending the individuals with pay. If you have concern about an employee performance, take proactive measures and address the issue as soon as possible. Dignity and responsibility, prioritize maintaining dignity throughout interactions. Take responsibility for ensuring dignity by promoting clarity in communications. This involves ensuring that your messages are understood and your comprehend and perspectives of other, fostering rapport in the process. Any questions so far? Or anybody can see my screen and hear my voice? Any issues?
So dignity and responsibility is separate to grievance. Is that correct?
Yes, that's another part from grievances. Okay,
Okay.
so you can raise grievances, but this is towards you as well. Take responsibility for ensuring dignity and keep dignity front for both sides. Okay.
Yeah. Thanks.
Clarity. Ensure you have been understood and ensure you that you understand. Sorry, guys, not bit well. Your responsibility, extends to ensuring that the employee comprehends the situation and has a positive experience during the meeting, irrespective of the outcome. Emphasizes that a grievance meeting is not a, confrontation, but an opportunity for resolution. Acknowledge the unpredictability of how an employee may react, even if they have expressed a desire to leave or downplay the situation. Be prepared for unexpected emotional reactions which may differ from the employee's earlier expression. So the sensitivity is crucial for fostering a supportive and constructive work environment. Tests, gain control, integration, multiple employee terms, wrongful dismissal, and employer independent contractor, uh, formation of contract, termination of contract, unfair dismissal, permitted reasons, inadmissible reasons and remedies. So redundancy, definitions, and compensations. So the HR, planner operates within a legal framework that safeguards individuals and group, aiming to ensure equitable treatment throughout the employee relationship, from staff, securing, staff sourcing to separation. So this overview focuses on key area of employment law. In recruitment and selection, the HR planner address equity concerns, emphasizing the prohibition of unlawful discrimination. The recruitment process and offer terms and conditions, including pay, pensions, and benefits, are scrutinized for discrimination based on sex, marital status, gender, reassignment, sexual orientations, race, nationality, disability, religion or belief, age, trade union membership, or status as a fixed term or part-time worker. So this comprehensive approach ensures fairness in all aspects of employment. Basis of discrimination. Uh, direct discrimination, treating somebody less favorably on the ground of their sex, race, or so on. Indirect, applying an apparently general rule, which is practice disadvantages one sex or race. So basically, direct discrimination where someone is treated unfavorably based on factors like sex or race. Indirect discrimination where a seemingly the general rule, this opportunity affects a particular group. Harassment, violating someone's dignity, creating an intimidating, hostile, degrading, humiliating, or offensive environment. And then victimizations, treating someone unfairly because, for example, they plan to raise discrimination-related grievances. So, harassment involving actions that violence dignity or create a hostile environment, and victimization, then treating someone unfairly for raising discrimination related grievance. Fairness and protection during employment. Uh, an employee has a number of rights throughout their terms of employment, which you need to be aware of. So here's a list with the resource you need to use to find out more. So, anybody can go through point one. Anyone? Volunteer?
So basically, regardless of what the standing of the individuals are who apply for the role, they should all be on an equal level and be based, a decision should be based on who is chosen for the role based on their merits
Yes.
and nothing else.
Yes.
Uh,
Yeah, carry on. Sorry.
yeah, so even if they're offered the role, they they should not be discriminated on pay either. So a female who's promoted should be on the same uh, pay level as somebody who's a male candidate. So these are the kinds of examples where they should be given equal opportunities in employment to develop, to progress, and be able to apply the right kind of support with training. So one individual gets training and their training is paid for, whilst the other candidate who may be experienced but doesn't get the training, or there isn't a budget for their training, and that is considered discrimination.
Yes. Must be equal. Sorry, anyone? So basically, employees have various rights during their employment. Okay. So discrimination is, not allowed at all in areas such as promotion, transfers, and training. Okay. Or and then we talk about health and safety. Under the Health and Safety at Work Act 1974, the employer has a duty of care towards employees and anyone else who may be affected by their business and its activities. So the Health and Safety Act 1974 imposes a duty of care on employees. So the Data Protection Act 1998 outlines principle of processing personal information. So uh, uh, information must be fairly and not lawfully uh, processed by a limited purpose, adequate, relevant, and not excessive, accurate, and up to date, not kept for longer than is necessary, processed in line with your rights, secure, and not transferred to other countries without adequate protections. Then Information and consultation of employees under the Information and Consultation of Employees Regulations 2004, employers with 50 or more employees must provide written statements which specify the main terms and conditions of employment. Uh, it terms pay statement items, pay statements, health and safety information, and information about the business economic situation and employment perspectives. So basically, these are most important items. So they must also consult with employees about occupational pensions, health and safety plan, collective redundancies, and transfers of business ownership. So basically, Information and Consultation Employees Regulation 2004 requires employers with 50 or more employees to provide written statement specifying employment terms, itemized pay statement information on various aspects, including health, safety, pension, and business perspective. Then family-friendly law falls under a number of headings, uh, uh, encompasses several categories, including maternity rights, adoption rights, parental leave, paternity leaves, and entitlements to request flexible working arrangements, regarding maternity rights, and employees anticipated the birth of a child is granted, various legal entitlements. So these includes the right of reasonable paid time off for, antenatal care, safeguarding against discrimination based on pregnancy, eligibility for statutory maternity leave, I lasting 52 weeks, nearly a year, and the right to receive statutory maternity pay or SMP for up to, maximum of 39 weeks, contingent on meeting specified qualifications. It is still 52 weeks. Anybody can tell me? I think so they're working on it, or is still on 52 weeks maternity leave.
Yes, it
I
is.
think it is, yeah.
Okay, okay.
There is discretion, some company policies.
Yeah, that's why my question is: it discretion? And I think so. They can
They can actually reduce it to 26.
reduce to 6 months
No,
as well.
no,
Yes.
no, that's wrong. Statutory maternity leave should be 52 weeks.
It should
52.
be.
If they
Oh,
want,
It should
if
be.
they want, they can increase, but they cannot decrease.
oh, they
Okay,
can't
so
reduce.
I'm telling you from personal experience, the company policy has stated 26 weeks, and they've applied that to staff. And I'm talking within financial
Yeah.
services.
Even
Also,
statutory maternity leave.
that is exactly what they've implemented. I know
Which
it's not right. I know it's wrong.
so
But
the staff,
these,
the employee can go to court.
exactly. And guess what happens to them?
Yes.
Disciplinary action against the individual, and then they're pushed out of the organization. So this is the reality of things that happen. Unfortunately, there are laws to protect them, but individuals are put into a corner.
The main reason is who was talking before?
Me, Swapna.
Yeah, Swapna and Haresh, or obviously everyone. The main reason is most of people don't know about their rights. Okay.
That's true because I know like a few years before. That's one of I'm actually from South India, from Kerala.
Okay.
So what happened, like few years before, there was one issue happened like this, then it came the result in the newspaper. Like actually, same thing for maternity, like they reduced the maternity leave, and then when she spoke about this, and then they did disciplinary action, but then she went to court and she won the full year of her full salary.
Yeah,
Did she
you're
get her
right.
job back?
I'm sorry.
Swapna, did she get her job back?
No, she told us she don't want to work there anymore because that will affect, right? That will definitely, she felt maybe, affect.
Yeah, it does cause trauma.
Yeah.
Unfortunately, how can
But
you
the
work for
court,
an
but the
employer?
court decision, they paid, the money because it was a court decision. Then after that, she don't want to go back to work. I think
Yeah,
nobody will want to go back to work in the same company.
exactly. I would agree with her. You're
Yeah.
absolutely right. Who would want to work for an employer who discriminates at that level when the law protects the individual? And this is the problem. A lot of employees are naive and they employ young people who are paid on peanuts and then they treat them like this. And it's in this country, unfortunately. I mean, it does happen around the world, but the laws of employment law we're discussing for our syllabus here, unfortunately, not everybody's aware. And this is the lack of education and awareness that
Yeah,
people are
basically,
missing.
I'll add some, my comments. Basically the main thing is, you know, people don't know about their rights. Okay, they don't know about laws, so we don't study laws. As you said, that they don't study their own laws, or they don't want to know about laws. Okay, they rely on, if in case of employment laws or these kind of stuff, they relies on, if you look at big picture, they rely on solicitors. Or if small kind of stuff like we are talking about maternity leave, paternity leave, or these kind of stuff, they rely on the unions. Okay, so I think so, normally they don't bother, or they don't I mean that they just fill in the blanks. Okay, so they don't much bother about everybody should know about employment laws. If you're working, you should read some, at least you should know about basic, your basic rights or basic laws related to employment laws, or your working conditions. And also, even people don't read, I've noticed that people don't read their contract even. Okay, working contract or conditions. So I think so that you should read about some basic employment laws, and your rights. Anyone else? Okay, so adoption rights of for individual adoption a child include protection from discrimination based on adoption, entitlement to statutory adoption leave lasting 52 weeks, conditional on meeting qualification, uh, and eligibility of statutory adoption pay for a maximum of 39 weeks, again subject to qualification. Uh, Parental leave is available to either parent without pay under certain circumstances. To qualify, sorry, conditions to qualify, the individual must have worked for the some company for a year or more, hold an employment contract, and be a parent listed on the child's birth certificate, adoption certificate, or have legal parental responsibility for a child under 5 or 18 if disabled. Then foster parents also enjoy specific adoption leaves rights, allowing them to take up to 13 weeks of parental leave to each child their fifth birthday. So if the child is adopted, they can take up to 13 weeks of parental leave until the 5th anniversary of placement or until the child's 18th birthday. So whichever comes first. Uh, Paternity leave and pay compensations are available for male employees, allowing them up to 2 weeks of statutory paternity leave under certain conditions, eligibility criteria, including being an employee with a valid employment contract, being the biological father of the child or the mother's spouse or partner, including same-sex relationship or being the child's adoption or the partner of the adopter. Additionally, the employee must have been with their employer for at least 26 weeks by the end of the 15th week before the baby's due date, or by the end of the week in which they are notified of being matched with their child. So this leave is granted to individuals fully engaged in the child's, upbringing, taking time of the support, the mother of care of the baby. Paternity pay is also available, subject to meeting the required uh, uh, qualifications. In case of emergencies, involves dependents such as a spouse, partner, child, parent, or anyone living in the household as a family member. Employees have the right to unpaid time of work. A dependent may also include someone reasonably relying on you for help in an emergency, like an elderly neighbor living alone in need of assistance. Uh, Right to request flexible working. Furthermore, employees who have continuously worked for their employer for 26 weeks and are parents of a child under 16 from April 2009, or have a disabled child under 18 receiving disability living allowance, are entitled to request flexible working. So this statutory right enables employees to seek flexible work arrangement to better balance their work and family responsibilities. Termination leave the organization or termination of employment within an organization can occur either voluntarily by the employee or through dismissal. So with or without notice, leading to the termination of the employment contract. Unfair dismissal occurs when an employee is terminated without a valid reason, or if the employer's actions are deemed unreasonable. So dismissal may be considered potentially fair under certain circumstances, including grounds such as misconduct, capability, assessing the ability to perform the job, redundancy, retirement, or legal restrictions preventing the employee from performing essential job duties. For example, driving ban for a job requiring driving. Uh, for example, some sales job. So additionally, some other substantial reason beyond the mention 5 categories may also be deemed as potentially fair ground of for dismissal. So this encompasses situation where reason of dismissal fall outside the conventional categories, but are still considered justifiable. Yeah, that's it for today, and we finish here, and this was our last session, learning outcome 4. And tomorrow we will discuss final session of this series, which is law of accounting series, which is assignment discussion. And I'll see you tomorrow at 2 o'clock. That's it, guys. Thank you very much. Any questions, concern, issues, anything?
Thank you. Thank you, Yasir.
Thank you.
Anyone?
May I just request? I don't think I've got a link for tomorrow's session. For some
Oh.
reason, I only got last one is today.
Who is this one?
It's Andrea, please. If you could email it to me or
Yeah,
don't know.
Andrea. Just do me a favor. You guys have my email and numbers. I don't have your email or number, but you can just drop me an email.
Okay.
As I said, that if any issues, concern or question, drop me an email at yasir@ukversity.co.uk, or also I have my number. I can't see any. I don't know why there is no a group, law of accounting group, but still wait.
I will drop you a line this
No,
afternoon.
there is a group for law for accounting. That's why I received this invitation today. But I didn't receive anything for tomorrow as well.
Oh, you haven't got anything for tomorrow as well?
No.
I think didn't we have the original email that was an original email that went out with all the links for all the dates that were sent one go.
You guys,
Yeah.
is there a group as well? Law of accounting group as well?
Yeah, but I think that
there is.
Yes.
Can you see
law
my
for
name? If
accounting.
any one of you can message me there, or can add me and message me there. Any one of you. 07. This is my number. 07-466-201-315. Can you please message me any? Then I will try to Oh, I message. Where did I message?
So guys, where is the group? You mean
Are you in
meaning
the
on
group, Yasir?
I even, to be honest, don't know. I'm not in the group, so that's why I'm saying that. Can you guys see me there in a group? I don't think so, because I can't see. I have a business, organizational, and some other groups, but I can't see law of accounting group.
No, this is IFA law for accounting, then GR. It has 25 members here.
The email, Yazir, the email that I've got is dated 19th of February. Time is 14:54. Amandeep from UK Versity emailed 32 candidates.
Any one of you have a link for tomorrow? Anyone?
Yes, I'll forward. Let me just highlight it right now and show it on the chat.
Anyone of you also message me as well. Can you guys see my number as well?
No, I don't think so. You are in this group, whatever group I have.
Yes, see, I'm a tutor and I'm not in the group.
Yes. Yes.
This is unfair,
True.
huh?
That's true.
Quite unfair, huh? I should
There is a UK, Yasir, UK Versity Online. There is a 0742437991. That is the admin actually.
Oh, okay. So this is why I don't know. Always a direct message comes your name only, Swapna, in my chat as well. Anybody can see my message now?
Yes, I can see your message. I just put a hi.
Oh, okay.
Yeah, I think
Ganesh can see.
Ganesh, yes.
So everyone got link now? Because Ganesh share with everyone.
One second. I will just copy the link here.
So if in case of any issue, all of you got my number now as well.
Yeah, I got the link now. It's fine.
Yeah, fine. Just anybody
Wonderful.
else? Ganesh, Swapna.
746.
I shared the link.
Amir.
2020.
Thank you.
No worries. I'll make sure.
Yeah, I'll have the link. Thank you. Thanks.
Everyone.
Yeah, thank you.
Yeah, I copied, yes.
Okay, so it's still in case of any issue, I think so I dropped my number as well. I mean that in case of emergency or tomorrow. So
great.
Okay.
Okay.
All right.
Thanks.
All right,
Thanks very
thank
much,
you.
Emma, and see you tomorrow at 2 o'clock.
See you
Thank you very
tomorrow.
much.
See you
Thank you,
tomorrow.
everybody.
Bye-bye.
Thank
Bye.
you.
Bye for now.
Bye-bye.
Bye.